Can you hear me now? Oh, what a great response. Good morning. Oh, that was good. Hi, I'll just repeat what I was saying, which was that I'd like to welcome everyone here in the room and online on behalf of the University of California, San Francisco Program on Reproductive Health and the Environment and the American Congress of Obstetricians and Gynecologists to our briefing on the Toxic Substances Control Act, which we will all now refer to TSCA by its abbreviation, an acronym, and the implementation that has been occurring over the last 2 years since its passage. And we will be having an amazing panel of speakers talk about some of the implementation issues, particularly as it relates to science and the public's health. So to introduce myself, my name is Tracy Woodruff. I'm a professor at UCSF in the Department of Obstetrics, Gynecology, and Reproductive Sciences. I run the program on reproductive health and the environment. Before joining UCSF as a faculty member, I used to work at the U.S. Environmental Protection Agency, where I was a senior scientist and policy advisor. I also have done extensive research on exposures to environmental pollutants, particularly during the prenatal period, and how this may adversely affect development, including adverse pregnancy outcomes and child health outcomes. And this morning, I will just give a very brief overview of some of the scientific reasons about why TSCA is so important to the public's health, and then some overview about the key areas where we are in terms of TSCA implementation at this time. And then I will turn it over to our speakers, who will be giving you more details about different aspects of TSCA implementation. So first of all, environmental chemicals matter to the public's health. So the data here that I have on this slide show a couple snapshots of some of the information of the science that we have produced, as well as the U.S. Environmental Protection Agency and other esteemed panels such as the President's Cancer Task Force. So first of all, the data from EPA show that there's thousands, actually trillions of pounds of chemicals that are produced every year in commerce. So it's 30,000 pounds of chemicals that are produced per person in the United States. That's about 9 trillion pounds. These chemicals are used in many different types of products that we come into contact with every day. They get into the air, into the food, into the water, where we are then can be exposed to these chemicals. So data from our own studies show that pregnant women across the United States are exposed to many and varied industrial pollutants. Many of these have been linked to adverse health outcomes, including adverse pregnancy outcomes and lower child IQ and male reproductive developmental health outcomes. The reality is that these chemicals that occur, these exposures that occur during pregnancy, they reach the fetus, and so the babies are born pre-polluted. This is a quote from the President's Cancer Task Force, which is a task force that's sponsored by the National Cancer Institute. So the concern is, as we have published in many of our scientific papers, that we are being exposed to these chemicals. They can increase risk of adverse health effects, and that we are observing these adverse health effects in the population. So the major law in the United States that governs industrial chemicals is TSCA, the Toxic Substances Control Act, which was originally passed in 1976, but was realized over many years to be inadequate to the task of keeping up and regulating toxic and harmful chemicals in the environment. So TSCA was amended 2 years ago in June 2016. There are some key features that are happening right now as part of implementation of TSCA that we will be talking about today, but in essence, the amended TSCA directs EPA to evaluate and limit dangerous chemicals. Importantly, TSCA includes a provision that EPA must consider susceptible subpopulations when they are evaluating risks and other aspects related to exposures to chemicals. Susceptible subpopulations include pregnant women, children, and workers, and we will hear more about that today. Also importantly in the legislation is that actions that EPA takes on the regulatory process, and I'll talk just briefly about that in a minute, can preempt the activities by states to do anything further on these chemicals. So the actions that EPA takes are very important because that is the final action that will be allowed as under TSCA. So since the passage of TSCA in June 2016, EPA was directed within the first 6 months to identify 10 chemicals that they would immediately put into a risk evaluation process, which I will talk a little bit more in detail. They did this in December 2016. Also during the first 2 years, there's a lot of activity that happens during the first couple of years of TSCA implementation as specified by the Act, and a lot of it is related to setting up the processes and procedures by which EPA will identify, prioritize, and evaluate risks for environmental chemicals. So in June 2017, as per the statute, EPA was required to promulgate a rule that set in place the framework by which they would prioritize environmental chemicals for risk evaluation and the rules by which they would then evaluate environmental health science evaluation under that risk evaluation process. Today, EPA is in the process of evaluating the risks for the first 10 chemicals. So the EPA process for existing chemical management. So these are for existing chemicals. These are chemicals that are already on the TSCA inventory and can be used in industrially used. So I'm not talking about new chemicals. So first, EPA has a process by which they prioritize chemicals. Chemicals can be prioritized either into low priority, and then there's no further assessment of that chemical. It's essentially deemed as safe. Chemicals that are deemed as high priority based on exposure and health data then enter into a risk evaluation process where EPA evaluates the scientific information on exposures and health effects to evaluate whether that chemical poses an unreasonable risk, including an unreasonable risk to sensitive subpopulations. If EPA decides that there is no unreasonable risk for that chemical is then essentially deemed as safe, and it also is preempted from any further state action. If it is decided that that chemical poses an unreasonable risk, it goes into risk management. EPA must develop rules to eliminate those unreasonable risks. Again, that it preempts any other state action on this chemical. So the decision about unreasonable risk is extremely important because it will set the standard by which these chemicals and people will be exposed to them in the future. So we have a number of scientific concerns about the approach that is being used to implement TSCA. First of all, it is very difficult to evaluate chemical risks unless you have sufficient information on the health effects that may be caused by that chemical. Things like, does it lead to adverse birth outcomes? Does it increase risk among susceptible subpopulations such as pregnant women and children? So decisions about chemical safety must be made on sufficient data. And right now there is a large lack of data on most chemicals that are being used in the marketplace about their health risks, about their ability to increase risks of adverse health outcomes. If we underestimate either the health hazards or the exposures, so if we don't know where all the different exposures are that people are exposed to, it could lead to underestimating risks. These are the first 10 chemicals that EPA is now evaluating. They represent over 1 billion pounds of production in the United States. They have chemicals that you probably are familiar with, like asbestos, trichloroethylene, and perchloroethylene, and they're used in many different types of places: dry cleaning, building materials, as solvents, furniture. So we are all have many opportunities to be exposed to these chemicals. I just want to talk briefly about some of the actual personal impacts of some of these chemicals. These are people who have been affected by each one of these 10 chemicals. So the first person here is Chris Penny of Florida. He was exposed to asbestos on the job. Those pictures are before and after he contracted cancer from asbestos. He died at the age of 40 in 2016. Below him is Drew Wynn of South Carolina. He just died last year from being exposed to methylene chloride. I'll just say that the use of this methylene chloride has been banned in Europe, and there's a safe substitute for this. He was 31 years old. On the right is Cassandra Little of North Carolina. She was disabled by 1-bromopropane, also on the top 10 list. She lost her job in 2003 and hasn't been able to work since then. Just to illustrate the other issue, one is we have to know enough scientific information about the health hazard. We also have to know where people are exposed. People can be exposed to chemicals in many different ways. There can be, because the chemical was used, for example, as a flame retardant chemical, it's used in computers or in furniture. It's made at the factory. It can be disposed of in a waste dump. Because some of these chemicals are persistent, they can migrate up the food chain, so we can be exposed into them in food. We can also get exposed to them in water. For some of these chemicals, EPA is not proposing to look at the legacy exposures that we may be experiencing because they get into food or into our water. It doesn't matter to you if you have a chemical and where it came from. You still have that chemical, and it is scientifically appropriate to evaluate the risk from that chemical based on that exposure. And if you don't do that, it will unnecessarily underestimate the risks. So with that, I'm going to turn it over to Eve Gardner. Really happy about our panel today. They're all really excellent experts, and we're so glad to have them join us today. So this is Eve Gardner. She's a staff attorney with Justice. She works in the Health Communities Program, and she's going to talk about EPA implementation of risk evaluations for existing chemicals. Thank you. Oh, I want to say one more thing. After all the speakers, we're going to have time for questions and answers.
Great. Thank you so much, Tracy, and thanks to all of you for coming. It's great to see such a great turnout to talk about TSCA. So as Tracy explained, TSCA requires EPA to adopt rules that lay out processes that it will use to prioritize chemicals and then evaluate the risks of high priority substances. EPA first proposed the framework rules late in the Obama administration, and then the rules were finalized in very different form by the Trump administration. Can you guys hear me okay, by the way? Yeah, okay, good. The final rules adopt the approach that the chemical industry lobbied for, an approach that defies Congress's intent for TSCA. The Trump administration rules have been challenged in multiple lawsuits that are now pending in federal court. The primary concern is that the Trump approach will result in risk evaluations that systematically exclude pathways of exposure and therefore understate risk, especially risk to vulnerable populations like pregnant people and children. So I'm going to go through now a high-level overview of what's wrong with these rules. First, Congress was very clear that risk evaluations must cover chemical substances, not uses of chemical substances. And the evaluations must encompass all of what Congress called the conditions of use, which are defined as the circumstances under which a chemical substance is intended, known, or reasonably foreseen to be manufactured, processed, distributed in commerce, used, or disposed of. In other words, the risk evaluation must cover the entire life cycle of a chemical, all pathways of potential exposure based on what is known and what is reasonably foreseeable. So flouting this intent of Congress, EPA's framework rules assert that the agency can pick and choose which conditions of use to include in risk evaluations. To make matters even worse, EPA does not bind itself to any particular criteria for which exposure pathways it will include or exclude. In other words, EPA, the Trump EPA, is asserting unfettered discretion to exclude known or foreseeable conditions of use from risk evaluations. TSCA does not allow this. The second major flaw is that Congress, when it adopted TSCA or amended TSCA in 2016, was very clear that risk evaluations must cover exposures to chemical substance if there is an ongoing use or ongoing disposal, even if the substance is no longer manufactured for that particular use. Defying this clear direction from Congress, EPA's framework rules state that if a chemical is no longer manufactured for a particular use, then EPA is going to ignore ongoing use or disposal. It's going to consider those to be not conditions of use and will exclude them from the risk evaluation. So under the Trump approach to TSCA, asbestos in roofing or lead in drinking water pipes will simply be ignored in the risk evaluations because asbestos and lead are no longer manufactured for those purposes. So I think it's obvious that if EPA doesn't consider ongoing exposure to asbestos or lead from those uses, it's going to end up with a risk evaluation that greatly understates risks. TSCA does not allow this either. So EPA has tried to justify this piecemeal approach by saying, oh, we're just going to focus on the conditions of use that have the greatest potential for risk. So at a very quick note, that might seem reasonable. But how does EPA know what exposures present the greatest potential for risk until it's actually done the risk evaluation? Plus, the risk that EPA says it plans to ignore actually can be quite great, like the risks from lead in drinking water pipes. Inevitably, EPA's concept of so-called greatest risk will fail to protect children and pregnant women because these populations have greater susceptibility to harm from exposures at even low levels. The third major flaw with EPA's approach in the framework rules relates to how it gathers information. Congress was very clear that when EPA conducts risk evaluations, it must rely on all reasonably available information. But the Trump EPA modified the Obama proposed rules to reduce the amount of information it receives. As one glaring example, under the proposed rules, it was considered a violation of TSCA for a chemical manufacturer to submit incomplete information about a chemical to EPA. That makes some sense. However, under the final rule, EPA changed this so it's now illegal for anyone, manufacturers or the public, to submit incomplete information. And this violation can actually be penalized with criminal penalties, including potential jail time. So, while it makes sense for chemical manufacturers to have to submit complete information, it makes no sense to put citizens in jail for submitting incomplete information, as if anyone even knows what it means to submit incomplete information, as if anyone in the public might possibly have complete information about a chemical that a manufacturer has made. So this vague provision will undoubtedly chill the public from providing EPA with any information about chemicals. So, in order to understand how flawed the Trump EPA's approach is, I wanted to give a 30,000-foot overview of the core purposes of TSCA and where this statute fits within the panoply of federal environmental laws. As I'm sure you know, most federal environmental laws focus on specific media, such as air or water or waste. But Congress recognized in 1976 that this piecemeal approach cannot provide true protections from chemical hazards. So Congress adopted TSCA in order for EPA to have the ability to regulate chemical substances comprehensively, looking at exposures from all media across the life cycle of the chemical substance. I'm just put on the screen some language from the original legislative history of TSCA back from 1976. It's clear that the Trump EPA approach flies in the face of this intent. So finally, I wanted to share with you the schedule for upcoming deadlines for existing chemicals under TSCA. Any day now, we expect EPA to release problem formulations for the first 10 chemicals. By December of 2019, EPA must have designated 20 new high-priority chemicals that will undergo risk evaluation. By the same time, EPA must have designated 20 low-priority chemicals, which are functionally deemed safe. As Tracy explained, they will undergo no further review, but those chemicals will not be, states will not be permitted to regulate them because the TSCA preemption will kick in. By June 2020, EPA must issue final risk evaluations for the first 10 chemicals, and then by December of 2020, EPA must issue final risk management rules for the 5 persistent bioaccumulative and toxic chemicals. So TSCA requires EPA to make many key determinations before the Trump administration leaves office. I strongly urge Congress to let EPA know that anything less than a comprehensive approach to risk evaluation across a chemical's life cycle with a particular focus on vulnerable populations is not consistent with TSCA. Thank you.
Thank you, Eve. Next, I'd like to introduce Dr. David Michaels, who's a professor at George Washington University in the School of Public Health. He is the former Assistant Secretary of Labor, the longest serving, I understand. OSHA, which he was in charge of, is in charge of regulations related to workers. He is going to be talking about the implementation of TSCA as it relates to worker health and safety.
Great. Good morning. Thank you, Tracy. In amending TSCA, Congress recognized that workers deserve no less protection from toxic chemicals than anyone else in this country. But the Trump administration, along with certain manufacturers of toxic chemicals, are trying to ignore the will of Congress. They're pretending that OSHA provides this protection. They're wrong, and they know it. But if they succeed, they are sentencing thousands of workers to exposure to chemicals that kill quickly, like methylene chloride, or more slowly, like trichloroethylene or 1-bromopropane. I ran OSHA for more than 7 years. No one, perhaps outside of Scott Pruitt's office, would claim that OSHA is effective in protecting workers from most, in fact, from almost all chemical hazards. There are thousands of chemicals in the American workplace, and OSHA has occupational exposure limits for 500 of these. And 470 of these standards date from the 1960s or even earlier. Many of these limits are dangerously unprotective. The OSHA standard for N-hexane, for example, is 500 parts per million. NIOSH recommends 50 parts per million. Workers get sick at 300, but OSHA can do nothing about that exposure because the standard is far higher at 500. So why doesn't OSHA just issue new standards? The Government Accountability Office estimates that on average, it takes OSHA 7 years to issue a new standard, but that's really a gross underestimate. It took OSHA almost 20 years to issue the new silica standard. It came out in 2016. It started in 1977. The amount of work going into each of these standards is enormous. Every standard takes dozens of staff and millions of dollars to do the studies that are required to justify the standard under OSHA law. The number of chemical standards OSHA has issued in the last 20 or so years? 3. As Assistant Secretary, I announced that employers should not rely on many of OSHA standards because they're simply not safe. No major chemical company follows OSHA standards in their own workplaces, and they'd be crazy to do that. But the self-employed, the small employer, they don't know better. And their workers pay the price with sickness and sometimes death. OSHA has reasonably protective standards for a few toxic substances, and these rules have been effective in reducing exposures and saving lives. But it's only for a handful. You've heard of some of them: asbestos, benzene, formaldehyde. OSHA issued a reasonably protective standard for methylene chloride in 1997. Not as low as it should have been set, because methylene chloride also causes cancer. And EPA's risk assessment found elevated cancer risk for workers, even if they use the recommended personal protective equipment. That's part of the reason EPA proposed banning the chemicals used in paint stripping. It simply can't be used safely by workers. But when the OSHA limit is followed, it does prevent tragic deaths, like those that have been occurring among workers exposed in bathtub stripping. However, even when OSHA has a somewhat protective standard, like methylene chloride, enforcement is challenging at best. Federal OSHA has enough inspectors to inspect every workplace once every 159 years. And there are huge gaps in OSHA coverage. The self-employed, workers on small farms, or millions of public sector workers, including many here in Washington, D.C., none of them are covered by OSHA. It isn't surprising, then, that workers keep dying from preventable exposures to chemicals like methylene chloride. Workers exposed to chemicals do not deserve less protection than the rest of us. Congress recognized this, and they told EPA to use TSCA to protect workers. As Assistant Secretary for OSHA, I represented OSHA at meetings with Congress on this, and once TSCA was amended, at meetings with the EPA, the White House, and across all the government agencies. There was clear agreement that EPA and OSHA both have the authority to regulate workplace chemical exposures. The work of the two agencies is complementary. Unfortunately, some manufacturers of toxic chemicals are lobbying EPA to defer to OSHA because they know what I just laid out. OSHA will not be able to issue regulations protecting workers from their deadly products. TSCA doesn't replace OSHA. Under TSCA, EPA can issue regulations that protect all of us, and that includes workers. And under TSCA, EPA can apply the latest scientific evidence and has, as you heard, strict timelines to complete its assessments. OSHA has no timetable for standards and could never meet the timetable set by Congress. So after OSHA issued its methylene chloride standard, some employers just switched to a chemical for which OSHA has no exposure limit. You also heard about 1-bromopropane. This is a dangerous neurotoxin that's also been classified as reasonably likely to cause cancer in humans. I call this regulatory whack-a-mole. During the last administration, we started the process of issuing a rule to protect workers from 1-bromopropane, but the Trump administration's OSHA has killed this effort. This is the agency the EPA wants to defer to protect workers. And finally, there's the OSHA body in the morgue requirement. OSHA can only issue a standard when it can show there's significant risk. When there's a new chemical which has not yet started injuring workers, OSHA's hands are tied, because in every standard, OSHA has to demonstrate the significant risk from the exposure. No matter how risky a chemical may appear to be, OSHA has to wait for the bodies. This clearly isn't what Congress had in mind when it told EPA to protect workers, but it is exactly what the chemical industry is lobbying for and what the Trump administration is trying to deliver. This has to be stopped. Thank you.
Thank you. I'm pleased to announce Monique Harden. She is the attorney with the Deep South Center for Environmental Justice. She has over 20 years of experience working on environmental justice issues with communities, especially in the Gulf Coast region. She's going to be talking about disproportionate impacts on communities of color and the implications of EPA's plans for these communities. Monique?
Thank you, Tracy, and thank you all for being here. I appreciate this opportunity to speak with you about the work of the Deep South Center for Environmental Justice on toxic chemical pollution and our concerns regarding the current efforts by the EPA administration that move our country in the wrong direction. The Deep South Center for Environmental Justice was founded in 1992 by Dr. Beverly Wright. We're located in New Orleans, Louisiana. And our mission is to provide research and capacity building to communities that began with communities located in the Mississippi River corridor, infamously known as Cancer Alley. My work at the center focuses on assisting community-based organizations in 5 Gulf Coast states to have a voice in decision-making that affects their lives and environment. One of the many concerns for us is that the current administration of the EPA is gutting the Toxic Substances Control Act, which denies justice to children, families, and communities who need the protection of this law. The photos you see, are from predominantly African-American communities in Louisiana and Texas, where much of the toxic chemicals in commerce are produced. Such toxic manufacturing exposes nearby residents to serious health risks and cancer. However, residents are not taking this lying down. They have organized and tirelessly advocate for their human rights to health and racial equality. In the community of Mossville, Louisiana, residents have pushed for TSCA reform. In 2013, Dorothy Felix, president of Mossville Environmental Action Now, testified to the U.S. Senate Environment and Public Works Committee in support of TSCA reform in order to strengthen its protections, not weaken them. Mossville is a historic African-American community that is surrounded by 15 toxic industrial facilities. Since Dorothy Felix's testimony here in Washington, D.C., Mossville residents have relocated away from their historic community in order to escape the toxic pollution. In Louisiana and across the United States, we are losing whole communities to toxic chemicals. For many African Americans and other people of color, environmental laws do not equal environmental protection. In the photo on the right, you see children playing on a seesaw in their community park in Norco, Louisiana. Behind them is a hazardous chemical manufacturing facility that is spewing pollution across the street from their homes. The year of the photo is 2000, which is 30 years after the Clean Air Act and other federal environmental legislation. The photo on the left is a child also playing on a seesaw in his community near Durban, South Africa. At the time of this photo in 2001, there were no environmental laws in South Africa. So in our country, predominantly African American communities have been unjustly excluded from environmental protection and live like those in other parts of the world where there are no environmental laws. The environmental justice movement has pushed through law and policy to remedy this problem, such as EPA civil rights regulations, Executive Order 12898, known as the Environmental Justice Executive Order, a precedent-setting international legal decision that has held environmental racism in the United States as a human rights violation, as well as TSCA reforms. The updates that have been made to TSCA and these amendments can help to change this picture of environmental racism. The law focuses on chemical manufacturing, processing, and disposal, which are all disproportionately located in communities of color. The law requires protection for people exposed to chemicals, including past uses of chemicals. Communities suffering from racially disproportionate pollution burdens should be included in this protection, but the current administration of the EPA has excluded them and disregarded protections based on past uses of chemicals. The current administration of the EPA has set out to undo the work of Congress in reforming TSCA to strengthen its protections against chemical exposures. We need action from Congress to ensure that TSCA benefits people who have been excluded from environmental protection on the basis of race and suffer the harms of toxic chemical pollution on a daily basis in their communities. Thank you.
Thank you. Finally, I'd like to introduce our last speaker, who's Dr. Date D. Nikola. He's a physician with the American College of Obstetricians and Gynecologists, and he's also an assistant professor in OBGYN at the GW School of Medicine and Health and Sciences. He is going to talk about why TSCA matters for women and children's health.
Good morning. This is a topic that is very personal to me, not only as a physician who takes care of pregnant women, not only as a husband who hopes to be a father someday, but as a human who doesn't like consuming toxic chemicals. And this is very important to our professional society as well, ACOG. So who is ACOG? We are the American College of Obstetricians Gynecologists. We represent 58,000 OBGYNs who practice here in the United States, as well as the millions of women who those physicians care for. And it's our job to establish the professional standards of excellence for women's health care. Sometimes that involves clinical guidelines, and sometimes that involves patient advocacy. And in the case of toxic chemical exposures, both have come into play. OBGYNs are particularly suited to address this issue. We provide more preventative services for women than any other type of physician in the country. Over half of the women in the country see only their OBGYN as both their specialist and primary care provider. But also, they are the doctors who are uniquely poised to intervene during this period of preconception and pregnancy when there's a critical window of human development. And I'll explain what I mean by that. The research in neuroscience shows us that there are certain critical windows of vulnerability during human development. Some of these are during the embryonic and fetal development, some are during infancy, some are during childhood and adolescence. And during these windows of development, any toxic exposure can have lasting effect across the entire life course. And specific to pregnancy, the critical window occurs during fetal development. And so toxic exposures at this time last not just during the time of the pregnancy, but across the entire child's life. And I think the millennials in the audience can relate to the phrase, living your best life. Parents should reasonably expect their children can live their best lives. ACOG communicates through professional guidance in the term of committee opinions. This is a committee opinion that we published back in 2013, and it specifically addresses the harmful exposures, the harmful effects that environmental chemicals can have. We heard earlier that every pregnant woman already is likely exposed to 43 of these chemicals. There's only so much a mom can do. We already tell them not to drink alcohol, drink less coffee, don't eat sushi. They can't control the air they breathe, the water they drink, or the food packaging that their food comes in. Furthermore, the underserved and minority populations, as we just heard, are disproportionately affected. There's a double hit phenomenon that happens when these populations already have stressors due to social determinants of health, and then they are disproportionately affected by these toxic chemical exposures. Earlier in, late in 2017, there was a JAMA, Journal of the American Medical Association, published about the environmental injustice of beauty products and cosmetic products that have some of the chemicals that have already been mentioned today. It was no coincidence that this publication first came from ACOG's Committee on Underserved Populations. And ACOG has developed certain principles to approach these toxic exposures as we would approach any toxic exposure during pregnancy. Pregnant women are a vulnerable population, and they should be considered that in any legislation. Unless we can prove otherwise, the potential exposure to toxic chemicals is an unreasonable risk. This is the same reason we advise not to consume alcohol during pregnancy. We don't know what the safe dose is. We are never going to expose women purposefully to find out what that safe dose is. We know some dose is toxic, so we recommend avoiding it. And the same exact principle applies to all these toxic chemicals, whether the information is thoroughly spelled out in the data yet or not. And really the burden must shift away from the pregnant women and the children to upstream when the manufacturers are developing these chemicals in the first place. It is truly unfair to treat our patients as the canary in the coal mine or as the guinea pigs and not expect the regulation to occur much higher. In medicine, people are very familiar with the pharmacology industry and the rigorous phase 1 through 3 controls that things go through, both in safety and efficacy before it reaches the level of consumption. It surprises and perhaps horrifies some people to learn that chemical substances go through nothing of the like and are just often put out there in the environment with really no safety or other regulation. And chemical assessments must consider exposures from multiple sources, as has been discussed. So in terms of ACOG's response to TSCA reform, ACOG welcomed the enactment of the Frank-Lautenberg Chemical Safety Act, and this passage was just one first step. As has been said here many times, it's not enough to pass it, it must be implemented. Some people might remember Jerry Seinfeld talking about taking a reservation. Anyone can take a reservation. It's really the hold part that matters. So passing this law isn't enough. The implementation really is the crucial part. And that is, I think, hopefully one of the strong messages that are received here today. How ACOG is engaging, we have joined with 2 large professional consortiums. One is Project Tender, that's with an E, Project Tender. It is targeting environmental neurodevelopmental risks. And this is a organization of toxicologists, health professionals, health sciences researchers who have identified these 6 chemicals that are clearly linked to toxic effects on developing a child's brain and are linked to neurodevelopmental delay. And they're listed here. Some of these have already been mentioned, and they relate to things that are environmental exposures, which I'll show in the next slide, and can fall under the purview of TSCA. The other consortium listed here is the Medical Society Consortium on Climate Change and Health. This is a unique consortium. It is comprised of 20 different professional medical societies representing nearly 500,000 physicians. That is about half of all US physicians. And they have come together with a singular message that environmental exposures are affecting health right now. The specific focus of this group is climate change, air pollution, and extreme heat, but the theme is the same, that these are environmental exposures. And patients are asking about this. Patients don't make a distinction between what the EPA and the FDA regulate. They are looking to government agencies to provide some security before they become the canary in the coal mine and see the toxic effects happening to them. And they're asking about cosmetic products and how this environmental injustice of beauty applies to them. They're asking about their cleaning products and what kind of regulation has gone in before they use them to clean the floors their children crawl on. They're asking about if flame retardants are in their children's bedding or the couches they spend the evenings on. And they're asking about what water bottles are safe. Do they have bisphosphenol in them? Is BPA-free something that's helpful? And they're looking for guidance. So as I mentioned, there's really only so much they can do, and they and Congress have both asked that TSCA be implemented to its fullest extent. Thank you.
right, thank you. Now we have some time for questions and answers. We have microphones in the room. If you would like to ask a question, please, I encourage everyone to ask a question. Anyone who would like to ask a question to ask, please identify yourself and speak into the microphone. So, I know the first question is always the hardest. Great, we have a taker.
Thank you all so much. Insay Witherspoon, Executive Director of the Children's Environmental Health Network. I think we heard from all of you in one way or another the various ways that the current efforts are very much not protecting, especially vulnerable populations as expected. And I think I also heard, especially in the first couple, especially Eve, your conversation about what Congress should be doing. Can you all give a little bit more detail as to what Congress should be doing right now to stay on top of the EPA to ensure that vulnerable populations are not missed as originally intended in the enactment of this Chemical Safety Act?
Right, Eve, I think you can turn it on there, right? She can speak from the...
Talk. Okay, does this work? Can you hear me? So, Congress can exercise oversight over the implementation of its law, and it should. I mentioned that one of the soon to be taken steps is that EPA will be issuing what it calls problem formulations for the first 10 chemicals that are going through the risk evaluation process. Those problem formulations are expected to lay out the scope of the risk evaluations, and in this case, the key thing is what's not included in the scope, which we expect will exclude workers and exclude the what EPA calls legacy uses of chemicals, even though these so-called legacy uses are resulting in a lot of ongoing exposures and they need to be part of the risk evaluation. So if Congress sees these problem formulations and thinks that they exclude pathways of exposure that Congress wanted to be part of the risk evaluation and therefore part of ultimately a risk management rule, then Congress should let EPA know that it's on the wrong track. And it should right that track before it completes the risk evaluations.
Next question.
Hello. My question is basically on long-term exposure and risk, because a lot of this seems to be pretty short-term. It looks like there's maybe a 2 to 3 year time frame from where you're initially having your problem formulation and ideally reaching a conclusion, and there doesn't appear to be anything to input new information into there. So what kind of solutions from the policy perspective should we be looking at in terms of revisiting compounds that had already had a risk evaluation made later on if a problem becomes apparent?
Well, that's an interesting... Do you want to answer that? I guess you could go back into the pipeline, right?
I mean, you could check. Oh, I was going to ask, do you want to say? I mean, I think one thing is that I didn't mention, so there's the problem formulations that are coming out. There will then be draft risk evaluations. And I think, if anyone who's concerned about the draft risk evaluation should weigh in the comment period, then ultimately there can be lawsuits challenging the risk evaluations if they don't include all of the exposure pathways and vulnerable populations. Ultimately, yes, one could petition. There's a lot of processes in TSCA. One of its strengths is that citizens can petition the agency to take legal action, to take protective action to protect populations, even if a chemical has gone through risk evaluation. So that's sort of the wonky legal response. David probably has a more practical standpoint.
My understanding is are you asking about new scientific data that's developed after these are done?
Oh, so could you identify yourself? Sorry, I forgot to ask you to do that.
Will Hartwig, I'm with Congresswoman DeGette's office, and I'm a chemist, which is kind of why I'm curious about this. But my concern is that initial cancer-causing properties might not be readily apparent, especially in higher-order animals, until years or decades later. Asbestos wasn't initially seen as particularly carcinogenic. That became apparent after long-term use and lots of exposure to workers. So what about comparable cases where initially it seems short-term or even medium-term there aren't any real risks involved, especially in animal models, and then later on we realized that workers suffered through a lot more exposure or it had longer-term effects that weren't really apparent, and maybe it wasn't something that on first blush was initially obvious to be something that's going to be persistent and bioaccumulative, and so we have to look at lower thresholds of exposure.
I don't know how TSCA covers revisiting, but that should be the least of our problems. I mean, we have so much data now that isn't being addressed, and if there are some studies down the line that should be incorporated, that's we'll get to that. But right now, the acute crisis is you've got a huge amount of data about all these chemicals, and EPA is doing nothing.
Right, but that is true. And I would add that there is test authority in the TSCA law that allows EPA, if they look at a chemical and say, oh, I don't have information about its carcinogenicity, they do have test authority to go out and require those tests. EPA has not to date done that type of activity, even though they could do this activity. And this is one of the advantages under the new TSCA, is that it allows this kind of test authority, which we think is extremely important, because your point is extremely well taken. You have these exposures, and then we may not discover until later that they're a health effect. We should make sure that we know about all the science as EPA is going through the risk evaluation, or even the new chemicals. We didn't talk about the new chemicals program, but it's also an issue in the new chemicals program. Do they have sufficient data to really make a health determination about these chemicals?
Mm-hmm.
Do you have a question? I think you...
Can I just add something on that? On the test authority, I think that's a really important point, that another way that EPA isn't implementing TSCA the way Congress intended, because that was that the test authority has actually always been in TSCA, but with the 2016 amendments, Congress changed it so that the test authority didn't have to be through a rulemaking process,
right,
which has, David mentioned, takes 20 years and requires something that looks like this. But instead now they can just order chemical manufacturers to do testing. And it was very clear that Congress did this because they want EPA to use this testing authority. And yet it's been 2 years since the amendment to TSCA, and they haven't once ordered testing.
And they could. Very easily. Yes? Yes, the microphone is coming to you right now.
Thanks. Hi, my name is June Taylor. I'm with the Environmental Protection Network. This focus has been on human health, which is often the focus of our environmental laws. But is there anything in TSCA that deals with aquatic health, for example? I mean, we hear about weird androgynous fish and various scary things that are presumably from these persistent endocrine disruptors or whatever. And I'm struck by the number of just the existing chemicals, never mind the new chemicals that weren't discussed. Does EPA really have the capacity to do this right now, or do they need an infusion of staff and other resources?
Well, I'm going to let Eve talk about the ecotox part of it.
So on the ecological harm. So the statute requires EPA to regulate to prevent unreasonable risk of injury to health or the environment. So we focus today on human health, but absolutely that's part of the equation, is environmental harm to species other than humans.
Yeah, I just wanted to comment too on the not necessarily the capacity, but the challenge that the agency has to upgrade their scientific approaches and really manage all these risk assessments that are ongoing, because it is a very big task, because because TSCA has not been, for existing chemicals, really been a focus of activity at the agency, and there's a lot of new, the original TSCA was passed in 1976. Risk assessment had a very specific way that it was done in 1976. It's evolved tremendously with a lot of new science that we have, but the risk assessment practices as implemented at the agency haven't kept up with the way that we have new science and ways to use that science in decision making. So it is a large challenge for EPA to be able to take the science and also the new approaches to how to evaluate that science and integrate it all into TSCA. So I would say that there's, so that capacity is definitely an issue. The challenge is that EPA currently, as they've issued out the problem formulations and the other pieces, haven't indicated that they're going to be incorporating these new scientific principles into how they're doing the risk assessment. So that's one of the reasons why we're talking about the TSCA implementation today. Yes, over here. Oh, could you talk into the microphone? Thanks. That way everyone can hear you that's online.
Marilyn Bracken, former EPA. Does the science issue that's been raised by Trump against about the use or the not use of science information, how is that impacting this legislation? His new comments about not using science.
Well, I would just, it's a little hard. I guess I would say. Yeah, Monique is going to take this, actually. She's going to answer this question. Monique, would you like to say some more? Yeah.
It's the driving force behind why we're.
I do think that there is a challenge is that sometimes there are predefined answers that are being sought in terms of policy goals that do not comport with the science. And so this means that the science is getting modified or pushed aside in ways that are not consistent with the science in order to achieve some policy goals. And so I think the example that we gave in terms of people are, if you are exposed to a flame retardant chemical, if you measure a flame retardant chemical in your body, you don't care whether it came because it happened to be in a pre-existing use and it's like contaminating the food supply anymore, or you get it from your contemporary couch. But EPA currently is proposing to parse up those uses and pretend that some of them don't exist when they're looking at exposures. This will underestimate risk. This is possibly to achieve a different goal than was in mind when TSCA was passed. So any more questions? Yes, we have one right here.
Hi, Tricia Coleman. Thank you for a wonderful panel, really outstanding. One of the questions that I have is trying to integrate all of the scientific evidence. So we have evidence from animals, from humans and epidemiology, new sorts of assays will be produced, and putting that all together. So on the clinical side, we have ways to do that. And I know, Dr. Woodruff, you've been a pioneer in the systematic review. Could you perhaps comment about the need to integrate evidence and what that will look like for the future as we move forward with TSCA?
Sure. So right now, one of the challenges that the agency has had in the past is that sometimes it's not been clear about the scientific basis of their risk assessments in terms of study use and how they evaluate studies. So there's been a big shift in how evidence is being evaluated in the environmental health sciences through a method that's called systematic reviews, but it's basically a method that's been derived from the clinical community, and it makes sure that the process for evaluating risk is transparent, captures all the scientific literature that's relevant to the problem, and integrates different streams of evidence, so human, animal, and now, because of the backlog on the science, a lot of in vitro testing could be incorporated into this. EPA has, in the Office of Research and Development, through their IRIS program, committed to using these types of methods to improve their risk assessments. The National Academy of Sciences praised them yesterday on this work that they're doing, so we are very pleased to see that. The implementation of TSCA actually in the risk evaluation framework says they're going to be using these methods, but we haven't seen the actual implementation of those, and what we've seen has not necessarily been completely consistent with how these methods, there's a long history and practice in these methods, hasn't been consistent with how these methods have been applied. So we're looking forward to seeing the problem formulations, because that should give us an ability to evaluate EPA's at least in TSCA, their approach to doing this type of science evaluation. So I think we are just about at time. Does the speakers have any final words that they want to give? I wanted to thank everyone for coming. We have food and coffee here available for people, and then the speakers are available to speak with you afterwards if you have any specific questions that you would like to ask us. And thank you for coming. And we have many materials related to the briefing available outside or on our website or with ACOG. So thank you again. Hi, Hi, June. Nice to meet you. Sorry, I just spilled water on my hand.
That's okay. So I'm going to give you my card.